You may have heard about the 10-year rule. Some people say that you can get a green card when you have lived in the US for 10 years because of this rule. That's not accurate. On today's program, I'm going to set the record straight. It's called cancellation of removal, not the 10-year law, and there are three different kinds. Cancellation of removal for green card holders, cancellation of removal for those that don't have a green card holder, and what's called VAWA cancellation of removal. Now we're going to go into detail for each one of them. I'm also going to explain how long it takes and how much it's going to cost you to get this form of relief.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
My name is Andrés Mejer. I'm an immigration attorney with offices in New Jersey and clients throughout the world. When I came to the US as a child, my family was a victim of immigration fraud. I make sure none of my clients experience what my family had to go through. This week, we're talking about the 10-year law or cancellation of removal. So first, let's jump right into it. What is cancellation of removal? People think that this 10-year rule is something that people get automatically after having lived in the US for 10 years and maybe having a child here in the US. That is simply not true. You need to be in removal proceedings. You'll need to have a trial. And at the end of that trial, you'll either get a green card or you're going to get deported. Nowadays, it's one or the other. There is nothing in between. So before you try to apply for this benefit, you need to be absolutely sure that you qualify. Otherwise, you've paid a lot of money to find yourself separated from your family. And let's be honest, nobody wants that. As I said at the introduction, there are three different types of cancellation removal depending on your particular situation. Now we're going to discuss each one of them, starting with cancellation removal for non-lawful permanent residents, otherwise known as non-green card holders. Cancellation removal for non-green card holders, this process is where the 10-year law, quote unquote, has come from. There are four key requirements. One, you need to show that you've been in the US continuously for the last 10 years. And it starts when the notice to appear is issued. That's the charging document that begins the removal process. So one is you've been here 10 years. Two, you've been a person of good moral character during that 10-year period. Three, you have not been convicted of certain criminal offenses. And fourth, this is usually the hardest for most people, because proving that you've been here for 10 years, at the end of the day, lots of paperwork, but not difficult. Proving that you're a good moral person just means you haven't been disqualified for certain discrete things. Proving you've not been convicted of a serious crime that disqualifies you. Again, it's just showing that you haven't been convicted of something, which is easy to do. The last requirement, but here you need to show that your close relative is going to suffer extreme and unusual hardship if you are deported. Now, what does close relative mean? Here, it refers to your parent, your spouse, or your child who's under 21 and unmarried, any one of those three who are US citizen or lawful permanent resident. So if your child is 6 years old and born in the United States, you may have a qualifying relative. Similarly, spouse or parent, but they have to be either a US citizen or lawful permanent resident. DACA holders, TPS, that's not enough. Now, what is exceptional and extremely unusual hardship? Every separation causes hardship. Again, what are we talking about? If you're deported, how a qualifying relative is going to suffer. Typically, that's because there's a separation. Either your qualifying relative is going with you and being separate from the rest of their family and friends and life here, or you're going without the qualifying relative, and how are they going to suffer without you? That's what we're talking about here. So every separation causes hardship. Extreme and unusual must be just that, out of the ordinary. So that means your US citizen or lawful permanent resident relative must have a significant medical, emotional, or psychological issue. Here's some examples. Parents with cancer or a severe medical condition, leukemia, Alzheimer's, you name it. Something that under the care of a doctor gets regular treatment. Now, it might be a cancer survivor that needs to check on a regular basis to make sure it doesn't come back. Spouse, again, cancer is always a possibility, but let's talk, maybe your spouse has been diagnosed with bipolar or schizophrenia or depression or anxiety. Here, they have a course of treatment, they have medicine that's been prescribed to them. Here they're under control, or at the moment they're asymptomatic, but they had those issues in the past and they may need their doctors again in the future. Now, a child, the most common one to be honest, is a child with either a severe medical condition or a learning disability. It could be autism, it could be any variety of things. I've had children that were born with heart conditions, children that were born, without use, maybe they're deaf, maybe they don't see through an eye, maybe they have some kind of physical deformity, whatever it is, but it has to be severe. Keep in mind, this is not hardship to you. This is hardship to you're being deported, so you don't count in this instance. The judge is really looking at your family relative and how they're going to suffer. It's not fair, but it is logical. The more serious the hardship to your significant, to your loved one, the better your immigration case. The healthier your relative is, the worse your immigration case. Again, logically makes sense. In fairness, it's not fair. How do you prove your case? So first, you're gonna need to fill out form EIOR 42B, and you're gonna need to prove each of the 4 elements. How do you prove that you've been here the past 10 years? Well, the most common proofs are medical records, taxes, leases, mortgages, school records, bank statements, photos, bills, or remittances that you sent back home through using MoneyGram or Western Union. To prove you have a good moral character, you may submit court or police records, or frankly, that you don't have court issues. Also, letters of support, people that can testify that you're an upstanding individual. You're going to need to prove that you're supporting the family that you say will be harmed if you are deported. It could include household, school, or medical expenses being paid for. You need to show that the relatives that you're claiming will suffer hardship have a legal status in the US and they have a relationship to you through birth or marriage. To provide the necessary proof of the exceptional and extremely unusual hardship, well, that's usually medical records, school reports, therapy records. All of those are helpful. Point is, it's not your opinion, it's someone else's opinion that your family member has a certain issue and will suffer because of it. What about if you have a criminal record? Many crimes make you ineligible for cancellation or removal, including relatively minor crimes like shopping or assault. If you think your case has been taken care of, I'm talking about your criminal case, and it's been closed, it still may disqualify you. So you got to take a look at it. Make sure you speak to a qualified immigration attorney before you find yourself in this position. It's very important to have your situation reviewed if you're trying to file for something, whatever it is. It doesn't have to be cancellation removal, but again, you want to make sure there's nothing that disqualifies you. Now, how this often happens is you're charged with a crime, immigration picks you up, and now you're defending the crime and you're defending yourself in immigration. Even if the crime goes away, you still find yourself in removal proceedings. So, scenario number 2, cancellation removal for green card holders. Remember, while a green card is called permanent status, it doesn't mean forever. It doesn't mean you can't be deported from the United States if, for example, you commit a serious crime. If you become a US citizen, however, it is much more difficult, but not impossible, for you to be deported. Pretty much only if you committed fraud in the procurement of your citizenship, and depending on where you are in the United States, they have a certain period of time to bring those allegations. It's why we recommend to every single one of our clients and all immigrants and anybody that listens to it, if you qualify for US citizenship, apply as soon as you can, because by not getting it, you may find yourself in an enviable position of defending yourself from removal when you otherwise wouldn't have to. Green card holders who commit certain crimes or violate immigration laws are subject to deportation, including, by the way, if you leave the US for too long and you try to come back in. When you're faced with that, you'll be put in deportation proceedings, and if you lose your case, the judge will enter a deportation order and you will lose your green card. If you win your case and you're granted cancellation removal, you're put back into the same position that you were before being placed into removal, i.e. you were a green card holder. Once the cancellation removal is granted, you keep your green card. In order to be eligible for cancellation removal for green card holders, you must file form EIOR 42A, as opposed to 42B, which was for non-green card holders, and you have to prove 5 key elements. First, that you have been a lawful permanent resident, a green card holder for at least 5 years since the application was filed. So when you file for cancellation removal, looking back 5 years from that date, and this is relatively easy to prove, you just look at your green card right in the middle. It says the date that you got it, and it tells you the date that the card expires. Number 2, you have continuously resided in the United States for at least 7 years after being admitted in any status and before the stop time rule is triggered. This gets complicated. There are 3 requirements here, so let's break them down. First, you lived in the US for 7 years. How to prove that you were here for 7 years? Well, we just discussed in the cancellation removal section for non-green card holders how to prove you've been here for 10. So 7 is the same proofs. The question becomes, when does the 7 years start? Now that's the second element here. After being admitted in any status. So 7 years after being admitted in any status. The meaning really depends where in the US you live. According to a 2018 Board of Immigration decision, this usually means when you receive legal status like a green card, student visa, H-1B visa, or something similar. But in the 5th and 9th Circuit, if you drove through a port and an officer waved you through, literally just, hey, come on in, without stamping your passport, that would be enough. Now, you're going to have difficulty proving that, but still, assuming you can prove you were waved through, that is enough in the 5th and 9th Circuit. Remember, US is divided into 13 circuits. My main office in New Jersey is in the 3rd Circuit, which includes New Jersey, Pennsylvania, and Delaware, and the Virgin Islands. By the way, I'd love to be in the Virgin Islands right now. New York is the 2nd Circuit, along with Connecticut and Vermont. The 5th Circuit consists of Louisiana, Mississippi, and Texas, and it's considered the most conservative circuit in the nation. If you remember, the DACA, the initial decision stopping DACA, came out of the 5th Circuit. The 9th Circuit consists of California, Arizona, Alaska, Guam, and Hawaii. Wouldn't mind being in Hawaii right now either. And it's considered the most liberal circuit in the nation, which is ironic. You have the most conservative and you have the most liberal, and they both agree waving through is okay. Now you ask, why is that true? Well, it's probably because the people that have come in and have been waved through are in those border towns. And maybe they moved to Louisiana or Mississippi, but really it's through tech because they entered through California, Arizona, or Texas. So that's where these cases has come up. I would assume if this comes up in other jurisdictions, they will likely agree. It's my assumption. We'll never know, right? Until it happens. Let's take a step back. Lived in the US for 7 years after having been admitted into any status. Now, if you've had your green card for more than 7 years, again, that's simple. It's pretty darn obvious. What about if you drove in through Texas and you were waved through 20 years ago, but you only got your green card 5 years ago? So only if you live in Louisiana, Mississippi, Texas, California, Arizona, Alaska, Guam, or Hawaii would you qualify today. Anywhere else, you're going to have to argue that waving through is sufficient. Because yes, you've had your green card for 5 years, but you haven't been in legal status continuously for 7 years. Waving through, one could argue that is sufficient, but an argument is not the same as something that's already been proven and upheld by higher courts. Now that we know when the clock starts, been here 5 years, green card, 7 years in some kind of legal status, so we know when the clock starts. Now we have to calculate when the clock stops. That's called the stop time rule. And there are 2 ways this rule is triggered. The most common is when the government files a complaint against you and putting you into removal proceedings. That document is called a notice to appear. It's telling you have to appear in court on a certain date at a certain time and the location of the court. The second, and this is an earlier method, is when you commit certain serious crimes. The time is considered stopped on the date of defense. Keep in mind here, if I'm charged with a crime January 2021, I may not be convicted until January 2023. But it's not when I was convicted, it's when the offense occurred. That's when the clock stops. If I entered in 2012 as a student and then I had an H-1B visa and then I got married and applied for a green card, so I've now had legal status for 7 years straight, but in 2018 I committed a serious offense. 2018 is when the clock stops. I don't have the 7 years. Number 4, you can't have been convicted of an aggravated felony. Aggravated felonies will have the harshest immigration consequences for a non-US citizen. It will almost certainly guarantee your deportation. You won't qualify for asylum, cancellation, removal from most waivers, and it could prevent you from applying to re-enter the US in the future. A crime does not have to be aggravated or even a felony to be considered an aggravated felony. Federal law designates about 35 crimes as aggravated felonies. Some are obvious, like murder, rape, and kidnapping. Other crimes aren't so obvious. For example, non-violent crimes like drug possession or certain white-collar crimes are considered aggravated felonies. Let's review. Must have had a green card for 5 years. Must have had legal status for 7 years. Stop time rule did not affect you. You've not been convicted of an aggravated felony. 5. You have never received cancellation, removal, or similar relief in the past. That's an easy one because you only get it once in your lifetime. Once you meet all of these requirements, so these are the requirements. Without them, you don't get to the next one. The next one is the discretion. This is where a judge exercises his authority or her authority. They're going to balance the negative factors with the humanitarian factors you present to decide, do you deserve to get this relief? Negative factors, well, typically it's what landed you in court. Any previous immigration violations, any previous crimes. In comparison to humanitarian factors like family ties in the US, hardship to you and family members if you are deported. Unlike when you don't have a green card, here you count. Because you are a lawful permanent resident, hardship to you in this case counts. In cancellation removal for non-green card holders, you don't count because you don't have that status. So family ties to the US, hardship to you and your family, ties to the community, employment history, business ties, time in the US, the longer you've been here the better, and proof of rehabilitation for any crimes you committed. Let's say you had a DUI 8 years ago. You did Alcohol Anonymous, you took a detox program, and you've never had it again. You're rehabilitated. In the past, cancellation removal, judges were very lenient and gave you the benefit of the doubt, knowing that you can only get this once. Don't count on that in the Trump administration or under judges appointed by his administration. They take a very hard line on each and every case. VAWA, cancellation of removal. Last week, we published a video about VAWA. That's the Violence Against Women's Act. Look below for the link where we discuss the requirements, the cost, and how long it takes. In that video, I talked about when you apply for VAWA, you can apply for waivers for some of the things that might otherwise make you ineligible for a green card. Those applying for VAWA can also apply for cancellation removal if they are in removal proceedings. If you win your VAWA cancellation removal and your abuser was a US citizen, you will immediately be granted the permanent green card. However, if your abuser was only a lawful permanent resident, a green card holder, you're going to get a temporary green card and you're going to have to apply for the permanent in the future. If you are in removal proceedings, you can still apply for VAWA. It's called an affirmative VAWA through the government agency USCIS by filing Form I-360. If the agency approves your application, the judge can grant you your green card in court. This could be a good option to avoid a trial, but your case might be delayed because you need to wait for USCIS to adjudicate it, and then you have to wait for a hearing before the judge in order to get your green card. So every case is unique. You have to decide what makes the most sense in your particular situation. In order to qualify for VAWA cancellation removal, you need to file Form EIOR 42B. That's the same as the first one we talked about, non-lawful permanent residents or cancellation removal for non-green card holders. And obviously, you have to prove each of the elements. What are those elements? You've been subject to battery or extreme cruelty by a U.S. citizen or lawful permanent resident, spouse, child, parent. Again, what is battery or extreme cruelty? Take a look at the video below. We went over that in detail last week. We don't have the time to go into that today again. You've suffered battery or extreme cruelty by a qualified relative, citizen, or lawful permanent resident. 2, you've been in the U.S. more than 3 years before you were put into removal. If your case takes 5 years, none of the 5 years counts. It's when does the complaint start? When is a notice to appear issued and served on you? 1, you suffered battery, extreme cruelty. 2, you've been here more than 3 years. 3, you've been a good moral person for the past 3 years. 4, your removal would cause extreme hardship to you, your child, or your parents. Again, to a qualifying relative, and you count for that. Spouse would also qualify, but not if your spouse was the abuser. And 5, you are not subject to any of the grounds of inadmissibility found in U.S. immigration law, and there are many of them. We've talked about those in the past. VAWA cancellation removal is like VAWA. There are similarities, but there's also differences that can limit your options. VAWA cancellation of removal can help a broader set of persons. For example, the following groups of people can file for VAWA cancellation removal, but they would not qualify for an affirmative VAWA scenario. Example number 1, children over 21 of a U.S. citizen, lawful permanent resident abuser. Once you're over 21, you typically aged out. For VAWA cancellation removal, they do not. 2, spouses of U.S. citizen or lawful permanent resident who've been divorced for more than 2 years. Your wife filed for you in 2010. You started the process. Unfortunately, you guys separated, and then you ultimately got divorced. You never got your green card. You suffered battery or extreme cruelty. 6 years later, immigration picks you up. You've been here more than 3 years. Even though you've been divorced now for over 4 years, which is clearly is more than the 2 years that VAWA typically gives you, in the cancellation removal side, you have that option to make that argument that you wouldn't otherwise have by just filing. You could not file Form I-360, but you could file Form EIOR 42B in front of an immigration judge. 3, you're the parent of an abused child of a U.S. citizen or lawful permanent resident who isn't married to the other person. Now, if you're not married, then the relationship isn't one that immigration typically considers. So you can't file Form I-360, but you can still use that under Form EIOR 42B if you are in removal proceedings. However, for VAWA cancellation removal, you must have been in the U.S. for 3 years. The affirmative VAWA does not have that requirement. It's another important distinction. How much does cancellation removal cost, and how long does it take? For now, we're talking about all 3, because at the end of the day, all 3 are the same. What you have to prove is different, but the process is the same. They all require filing an application, filing supporting documents. You're going to have to go to court each and every time, and then you're going to have a trial. So those steps, those processes are the same, irrespective whether you file for cancellation removal as a green card holder, as a non-green card holder, or under VAWA. It's difficult to tell you the complete cost for cancellation removal because every case is unique, particularly here, but I can give you a structure to better estimate what your investment's going to be. We first charge the cost of the application, again, irrespective of which of the 3. Green card holder cancellation removal, non-green card holder cancellation removal, or VAWA cancellation removal. It's still a set of applications with supporting documents. What those documents are depends on which of the 3. We charge $6,000 to $9,000 for either one of them, depending on the complexity of your individual case. We also do background search for each adult. We charge $1,000 per person for this. So we look at all the FBI, motor vehicle, and FOIAs from the 7 immigration agencies. We want to have whatever the government has for you. Depending on what we discover, we may have to request to reopen a prior criminal conviction. Now, we're only going to recommend to reopen if the conviction could disqualify you from cancellation removal. That cost really depends on what the conviction is, but it's typically between $3,000 and $15,000. It's rare to have one that's $15,000. Again, it depends on what the crime is. Is this process, this application only for you, or are you also including your spouse or children? We charge a nominal fee of about $1,000 for each family member that we are including in this process, and we have to look at that individual. Do they need waivers? What's their background look like? Is there things that make them ineligible? So every case is slightly different for that reason. Every court appearance, except for the last one, we charge $1,500 to go with you to court. These are called master calendar hearings. It's more like a status conference. You typically have a year between each court appearance in Newark, New Jersey, but every court is different. It all depends on the judge's calendar and how many cases the judge has pending at the time. So a new judge could have fewer cases, which means your case could move faster. Your last court hearing is called your individual hearing or your merits hearing. This is your trial date, and we charge $5,000 to prepare and go with you. There is a lot of work that goes into that trial. This is where we present your case to the judge Today, it's taken over 2 years from your last master calendar to a merit state hearing in New Jersey. But again, that all depends on your judge. Some judges are more than 3 years out, some judges are 4 years out. It depends on the judge and it depends on the court. In the main, you will have between 2 and 3 master calendar hearings before being issued your merit state. However, every case is unique and sometimes this requires additional hearings, sometimes it's less. We've had cases where the first time we went to court, we were given the trial date and we wanted it and we were happy to get it. But still, we had to wait many years. Again, it's for this reason that cancellation removal typically take between 3 and 5 years from your first hearing to your last. The success rate is much higher for those who hire an immigration attorney in immigration court than those who don't. If you're in removal and you don't have an attorney, find one fast. Best advice I can give you. If you or a loved one are in removal proceedings, call us immediately. We'll walk you through the process. We'll tell you what to expect and we'll evaluate your individual factors. What can you do if you lose at trial? Well, if your cancellation of removal is denied, a judge will file an order of removal, meaning order of deportation. But you can appeal it to the Board of Immigration Appeals. If that doesn't work out, you can appeal it to the Circuit Court. If that doesn't work out, you might be able to appeal it to the Supreme Court. Sometimes there are clerical errors and you can request a new hearing with the same judge. Every case is unique. Watch out for scams because there's a lot of them with the law of 10 years. Remember how I started this video talking about the 10-year rule? Well, there's a lot of scam artists, especially notarios, who've told people, hey, if you've been here for 10 years, I can get you a green card and I can get you a work permit. Don't worry, pay me and trust me. I've had way too many clients that have fallen into that situation from typically non-attorneys, but sometimes even some attorneys don't go to the detail that we are going through here and clients just don't know. Now, these individuals, these scam artists, they claim they can apply for your cancellation removal for you. What they're really doing is filing Form I-589, which is for asylum, and it could put you in a worse position than you started with, particularly if you don't qualify either for asylum or for cancellation removal. Now what you do, you get work authorization and you will later get deported. That doesn't do you or your family any good. Don't fall for the scam. I'm not saying never file for cancellation removal. There are some circumstances, even when you're not in removal proceedings, that you may want to put yourself in removal proceedings to file for VAWA, for example, or cancellation removal for non-green card holder. But you have to do it judiciously and you have to do it from an informed position. Contact an experienced immigration attorney who's going to do this right for you. Time is of the essence and we're happy to get started working on your cancellation removal for you today. Thanks for watching. Please share with your family and friends. See you next time.